SMU constitutional law professor Dale Carpenter, thank you so much for joining us. First, your reaction to the federal judge's ruling on the Texas Heartbeat Act, which came out last night.
This was a very broad ruling, and it was about as favorable as it could be for abortion rights advocates.
And what were your main takeaways from it? The judge had a very strongly worded order.
Well, the judge clearly felt very strongly that this law is unconstitutional, and he was the first judge to rule on the merits of this kind of law, and did so, I think, in unequivocal terms. He also spoke very strongly about the mechanism that Texas attempted to use in enforcing the law, the private enforcement mechanism, and strongly condemned the idea that Texas could evade the judicial review system by trying to route enforcement through other private citizens.
The other key takeaway was that he essentially allowed abortion providers to go back to performing these procedures for women.
I think he did as much as he could do to allow the abortion providers to go back and perform these abortions that are banned. And that included, by the way, not only enjoining the state of Texas, but all of the employees and officers of the state of Texas, including the state court system and the state court clerks. So he did about as much as he could do to grant them the remedy that they wanted to have granted. Now, go ahead.
I was just going to say, he essentially ordered them to basically stop these lawsuits from what, being filed in the first place?
So he did a couple of things. One is that there are some existing lawsuits that have been filed in state courts under this law. He ordered that all of that litigation be called to a halt. He ordered the state of Texas to put notices up on all of the court websites that said, we are not going to be allowing the filing of these lawsuits for now, at least during this temporary injunction. So the state courts both have to stop any existing proceedings and cannot even allow any further proceedings to be docketed. That's a very strong kind of an order. Now, whether it actually allows the abortion providers to safely continue abortions in Texas, I think, is an open question. The reason for that is that under SB 8, they would still be liable for any abortions that they perform now if the judge's decision is subsequently overruled.
So what you're saying is that even though they would be allowed to perform these procedures, they do so at their own peril?
That's exactly right. And I think some of them may wait until there's a little more clarity about this, especially from a higher court.
Which brings me to my next question, because the state of Texas and the other intervener defendants filed an immediate appeal. So this goes up to the Fifth Circuit Court of Appeals. And if I'm not mistaken, my memory serves correctly, you clerked for one of the judges on the Fifth Circuit Court of Appeals. What do you expect to happen when it gets up there for a judicial review?
So the state is going to attempt to at least get the Fifth Circuit Court of Appeals to stay the judge's temporary injunction against Texas and the state courts. So they will ask the Fifth Circuit simply to put a pause on that order. The judge himself in Austin refused to stay the effect of his order. So I would expect that's what Texas is now going to ask for. And there certainly is a prospect that his decision will be stayed by the Fifth Circuit Court of Appeals, at least for a while, and we won't know how long that is. So it could very quickly become called to a halt. At least the judge's decision could be brought to a halt.
And so If they do issue a stay, like you said, again, abortion providers would no longer be allowed to do that until the Fifth Circuit takes a closer look at this. It is considered one of the most conservative appellate courts in the country, isn't that right?
That's right.
And so, what do you think some of the deciding factors would be? What would they have to look at, the appellate court, in deciding what to do and how to rule?
Well, I don't think they would at least initially look at the question of the merits of the law as to whether it's constitutional or not to ban abortions after 6 weeks. What I think they would do possibly is stay the effect of the judge's decision on the basis of some jurisdictional issues. These are issues that involve things like whether the United States even has a cause of action in this case, whether it can even file this lawsuit, and whether the remedy is appropriate, especially insofar as that remedy is enforced against state court judges and clerks. That is a very broad part of this order. I should add that there is an additional step, and I don't want to miss this, but there is an additional step after the Fifth Circuit. If the Fifth Circuit stays the judge's order, of course, then the DOJ could go and attempt to get the United States Supreme Court to lift that Fifth Circuit stay. And then we'd be right back where we were on September 1st with the ball potentially in the Supreme Court's court.
And if that's the case, would they then, the Supreme Court, have to have a full hearing on this? Or would it be, again, up to, one of the justices to consider this as an emergency request, and then we go through that process again?
Yeah, I doubt that the Supreme Court would have a full hearing right now on an emergency basis on this matter. It would be up to a justice to refer this matter on an emergency basis to the full court, just like they did before, and then see whether things have changed in the last month such that the Supreme Court is willing to intervene, unlike what happened on September 1st, when it was not willing to intervene, even though it suggested that there were serious constitutional questions raised by SB 8.
And then it would go back to the appellate court, right? I mean, the appellate court can still go through its process of considering the case, right? As if it were kicked up to the Supreme Court.
Yes, and if the Supreme Court, let's say, for example, the Fifth Circuit stays the judge's ruling in the injunction that was issued last night. Let's say the Fifth Circuit stays. If the Supreme Court said, no, we're going to lift that stay and allow the judge's order to go into effect, then I think the case would go back down to the lower courts, maybe to the Fifth Circuit for some review by the Fifth Circuit, and we might have another decision further on down the road. And that all depends on a whole lot of things happening in the meantime. So I don't know what the outcome would be, but I think in the immediate future, that is in the next few days, we can expect a flurry of excitement surrounding the United States Court of Appeals for the Fifth Circuit and possibly the United States Supreme Court.
All right. Dale Carpenter, constitutional law professor at SMU. Thank you so much. As always, we appreciate your insight into all this.